Good morning, everyone. Happy Thursday, and thank you for joining our webinar. I'll give everyone a moment to log on here before we get started with our presentation on music licensing for restaurants. All right, so we'll do a brief intro here as people start to join. My name is Kara Heifel. I work for the Illinois Restaurant Association. And again, thank you for joining us today for this webinar on music licensing and how to stay legal and safe and also drive revenue. We have a lot of experts that are about to start presenting. During today's webinar, we will hear from BMI and Fox Swivel Law Group. This webinar is also being broadcast live in English, Spanish, and Mandarin Chinese. Please use the interpretation button in your toolbox there to use those interpretation resources as needed. This webinar is being presented by the Illinois Restaurant Association, as well as the Cook County Small Business Source. And the Cook County Small Business Source is a great partner and a free resource. It was originally established to ensure that businesses emerge from COVID-19 intact and positioned for growth. There are a lot of free resources here at no cost, including business advising and other events that we, as a partner of the Cook County Small Business Source, host. We encourage you to sign up for one of these free resources at cookcountysmallbiz.org, and that's on your screen there. And again, everyone will get this slide deck as well as this recording after the conclusion of this webinar. And before we turn it over, I want to remind everyone that myself here at the Illinois Restaurant Association, as well as our entire staff that is small but mighty, we remain a resource for you as well. IllinoisRestaurants.org. We encourage you to sign up for our newsletters and check out our website for any updates that are pertinent to your operations. And I also want to say, for this webinar, please use the Q&A button in your toolbox of Zoom, and we will be sure to answer those questions at the end. If you see a question that you particularly like, then just give it a thumbs up so we can prioritize it, and we will do our best to get to all of those questions before the conclusion here. Now, without further ado, at this time, I'd like to introduce our panelists. With us today are Dan Spears, Vice President of Industry Relations at BMI, Steve Reynolds, Partner in Intellectual Property and Litigation Groups, and Scott Schoenfeld, Partner in Hospitality, Corporate and Securities and Real Estate Groups at Fox Swivel Law. And without further ado, I will hand it over to our friends at BMI. Dan, take it away.
Okay, thanks, Kara. Thanks everyone for joining this webinar. I know it's not the sexiest subject, but we'll try and bring sexy back today in the music licensing world. And hopefully by the end of this presentation, you'll have a much greater understanding of what oftentimes is a very confusing subject matter. So let's move forward, and I'll tell you a little bit about what we're going to cover. Very briefly at the outset, I want to just mention the results of a recent survey that we did with a national research group about the impact that music has in the experience of going to a bar or a restaurant. We, of course, will tackle the subject matter of music copyrights. What are they? What is licensable in your venue as it pertains to copyright and public performance? Most importantly, I think in this presentation, we're going to talk about who the various performing rights organizations are. Because I think you get calls from acronyms all the time, like BMI and ASCAP, and wondering who they are and whether they're legitimate or not. We'll talk about each of those organizations so that when you do get a phone call, you're armed with information. Strength is knowledge, and we want to make sure that you're strong by the end of this presentation when interacting with those performing rights organizations. You know, Steve and Scott will probably spend more time talking about the legal ramifications of not licensing music in your business. We'll talk about very briefly how to simplify the booking process for live music. Many of you might be just starting out with a live music program in your venue and don't know where to begin. And we're going to give you some tips on what to do to start that music program. So let's get started. We'll talk a little briefly about the research survey study that we did recently with NRG. We have the next slide, please. Without getting too much in the weeds on this, we basically wanted to do a survey to find out what kind of value did music bring to eating and drinking establishments. This is the methodology. As I said, I won't go through it. The survey is available on our website. You can learn more about it. Honestly, the biggest thing that I think this survey has revealed is that people really do spend time thinking about the impact that music has on their dining experience. You'll see from these statistics, they will consider music when making a decision what restaurant to frequent. They will look at the music when deciding whether they want to stick around afterwards and have an additional drink or a dessert or what have you. So again, this is all on our website, and if you choose to drill a little deeper, I think you'll learn more about it. But again, it's mostly showing the important synergy that music has in a dining experience. So let's move forward to copyright. Many of you probably know this, but I just want to reiterate that the copyright law really protects intellectual property. And I think it's a very hard subject matter for some people to get their arms around because it's not tangible, right? It kind of floats in the air sometimes when you talk about music. But the copyright law also protects literary, whether it's a movie, a television show, your recipe for your filet mignon, whatever, how you prepare it. You may have a special recipe. Of course, that's all considered intellectual property. But the piece of intellectual property that we're going to be talking about today is the music side. This is the bundle of music rights within the copyright law as it relates to the use of music. We'll start from the bottom and move up. Synchronization license or the synchronization right is something that is owned and held by the songwriter and the publisher. We all know what a songwriter is. Many of you may not know what a publisher is in the world of music, but publishers own the copyrights to songs. So for example, I'm a songwriter, I'm in Nashville, I'm trying desperately to get my songs noticed by artists, I'm trying desperately to get the up and coming country artist, whether it's Morgan Wallen or whomever, to record my songs. It's very hard to do that without the help of a publisher going out and representing my catalog to all these artists that might potentially be able to record those songs. So what I do is I affiliate with a publishing company. And as part of that affiliation, the publisher takes over the ownership of that copyright. And most would say, well, why would you give up ownership of that song? Songwriters do it because without a publisher advocating on their behalf, the songs don't have any life. So even if it's a great song, if it's not going to be recorded by an artist, it's not going to be put in a television show or a movie or what have you, then it's not going to generate revenue. And so publishers play that role. They're kind of agents for songs. So they not only will get songs recorded by artists, but they'll also try and get placements in television and movies or commercials. And that's the synchronization right. When you're using a piece of music in video for a television commercial or as part of the soundtrack for a movie, the producer of that movie or that commercial needs to go to the publisher and negotiate what's called a synchronization right. Again, probably doesn't apply to you. Might apply to you if you consider using music in a commercial for your restaurant. Usually cost prohibitive to spend that kind of money to get a sync license for a popular song included in your commercial. The mechanical royalty or the right of reproduction is when a piece of music is sold, either digitally downloaded or for those of you that are buying vinyl these days, or maybe even CDs, which are making a comeback, a piece of the sales from those from the physical sale or the digital download goes to the songwriter and publisher. It's not very much money because no one's buying albums these days, right? It's a singles world. So if you write a song and it's on an album, 20 years ago, you'd make a lot of money if it showed up on a George Strait album. Today, it needs to be on the radio. for you to get any money at all, which leads us to the public performance right. And that's what we're primarily talking about today, is when songs are played publicly by a business, whether that's a bar or a restaurant, a television network, a radio station, Spotify, Pandora, your favorite aerobics class. Anytime music is played publicly, the business owner, the entity from which that music emanates from, must secure the public performance right. And this is what BMI represents. We protect the public performance right on behalf of songwriters and publishers, and we track it and make sure that songwriters are fairly compensated. We can move forward. So what's licensable in your bar or restaurant? What is considered use of music that must be licensed? Well, if you're blasting your favorite commercial radio station in a very large restaurant with 10 speakers, you need a license for that. Even though the radio station has a license with BMI, this is considered under the copyright law a second public performance. You need to license it. Now, there is an exemption. If you are a smaller business with square footage, I believe it's like 3,750 square feet. If you're less than that and you're booming the radio station into your business, you have an exemption. Congress revised the copyright law a number of years ago with what was called the Fairness in Music Licensing Act, and allowed for an exemption for small businesses using commercial radio. But that's only for a commercial radio station. It doesn't apply to any other music use. This, of course, is the most obvious form of music. Live music, bars, of course, feature, and restaurants too, singer-songwriters, maybe even a band on Saturday night. That is absolutely something as a business that you need to license. DJs, a lot of bars and restaurants are featuring DJs these days. That is licensable. Karaoke as well. You would think perhaps the DJ would be responsible for licensing that music, or the producer of the karaoke system, but in reality, it's always the business that uses the music that's responsible for licensing. That's what the copyright law says. That's how Congress chose to write it years ago. Televisions. So this is a very confusing subject matter for a lot of folks. If you are a business that has 3 or 4 TVs in your lounge or your pub, and you have the audio turned on, those television sets, you are responsible for licensing the music contained in that audio. You would think, oh, I have a commercial license with DirecTV or Dish. They're responsible for that. No, by getting the commercial license with DirecTV or Dish, you're only getting the video. The audio, under the copyright law, is the responsibility of the business. So if this is your only form of music use in your business whatsoever, and you want to avoid paying licensing fees to the respective performing rights organizations, turn the audio off. Now here's some commercial music services. Well, these are just examples, but 99% of all commercial music services license the music on your behalf. So I own a restaurant. I don't have any live music, don't have any DJs or karaoke. I simply have background music to create ambiance for my customers, and I'm using Mood Media or Soundtrack Your Brand. All of these commercial music services pay the performing rights organizations so that you do not have to. So if you have a license with a subscription with Mood Media, and that's all you're doing music-wise, and you're paying BMI as well, you're basically double paying. So you don't need that license with BMI if all you have is a commercial music service, because they're the ones that are taking care of the licensing and paying the fees on your behalf. Now, if you are using your own personal account on Spotify, you've got a great playlist that you love, you plug that into your sound system. It's not a business account with Spotify, but it's your own personal account. You're responsible for licensing that, because those businesses are not doing that. Those streaming services are not doing that for personal accounts. So this is just a general explanation or visual. It kind of gives you a sense of the role that BMI plays. Basically, a songwriter, a composer, affiliates with BMI earlier in their career, or any performing rights organization. We'll get into the others in a minute. They grant BMI permission to basically license their music. So we then go out and license that music on behalf of the songwriters and publishers with the businesses that actually are performing that catalog of music. I used to call this the circle of life. And then someone said, Dan, this is a square. So this is the square of life. Songwriters affiliate with BMI. I've listed some very well-known artists that also happen to write music, just because most of the songwriters we represent that have written most of the big hits that BMI represents, you've never heard of. Particularly in the country genre, a lot of Nashville songwriters behind the scenes that are writing hits for big artists that you don't know their names. They're anonymous. All they do is write songs for a living, and they're the ones that really depend upon those licensing fees that you pay. But for the purpose of this slide, to give you some recognizable names, we've listed some of the more high-profile artists who actually write as well. So Taylor Swift joins BMI at a very early stage of her career, says, please BMI, represent my catalog. We go out and license her catalog to the restaurants, bars, hotels, fitness clubs, what have you, that use her music. We then track those performances, and then every quarter, we pay royalty checks out to our songwriters based upon those performances, whether it's radio, TV, hotel, bar, international, streaming, you name it. So that's kind of how the ecosystem works. Now, for those that that have music from other countries, and I know we perhaps might have some folks on this call that are featuring music from South America or what have you. We have reciprocal agreements with 90 sister societies, whereby they collect licensing fees on our behalf for the public performance of music by BMI songwriters in their respective countries, and then we do the same for them. So, for example, if you're a songwriter from Argentina and you've written a song that happens to be a hit here in the US, we are collecting those licensing fees on behalf of that Argentinian performing rights organization, paying it to them, and they're paying it to their songwriter. But your agreement with BMI covers all of that music. So you don't have to worry if you're featuring international music. You don't have to affiliate or get license agreements with all these international societies. We have agreements with them that allow us to license that music on their behalf. So to me, this is probably one of the most important aspects of this presentation today, because it's very confusing. This space is getting more crowded daily with more performing rights organizations. So we're going to take this PRO by PRO. These organizations all do the same thing. They all represent the public performance right on behalf of the songwriters and publishers that are affiliated with their companies. ASCAP, will start there. ASCAP is the oldest performing rights organization in the country, founded in the early 1900s. Primarily, at the time, they were representing some of the more traditional music, right? Radio was the biggest consumer of music at the time. The George Gershwins, the Stephen Fosters, ASCAP represented them. As you can imagine, when you have one game in town, there's a possibility of monopolistic tendencies, and that's what happened back then. Because they were the only game in town, they were doubling, tripling their rates every year, and the broadcast industry, the radio industry specifically, was getting tired of that. They wanted to do something that would create a competitive music source that could bring ASCAP's rates down. The other thing that was going on at the time, I think it's kind of interesting for those that are music buffs. In the late 1930s, if you saw the Ken Burns Civil War documentary, that's when this influx of music from Appalachia came about. And that's really the foundation for so much of what we love in music these days, whether it's the Chuck Berrys or the Muddy Waters. These all these forms of music really have their roots in Appalachia. So when these songwriters came in the late 1930s, they wanted to get their songs on the radio. They wanted to expose this music to the general public. But ASCAP had a very strict requirement. Songwriters with at least 2 established hits on the radio were only allowed to join ASCAP. If you weren't on the radio, you could not be a member of ASCAP. Well, that didn't work for these new Appalachian songwriters. And BMI was formed as a result by the radio industry to not only bring the rates down, but to open the door to these new forms of music. And as a result, to this day, BMI is owned by the radio industry and the TV industry. Shares of stock were sold as seed money to create the company, and we had an open door policy that continues today. Of course, ASCAP had to change their policy, and they now open the door to all genres. The two things you need to know about ASCAP and BMI, these are the two biggest performing rights organizations. BMI represents 50% plus of all the music out there in the marketplace. ASCAP 40 something. It all depends on you know, the time of year that you're asking this question, because songwriters sometimes can change affiliations. But for the most part, between BMI and ASCAP, we're looking at 90% of the music out there. The other thing you need to know about ASCAP and BMI is because we are large companies and because there are concerns about antitrust behavior, the Justice Department created consent decrees in the 1960s that govern how we do business. And one of the aspects of the consent decree that actually is relevant to you all is we must treat similarly situated businesses in a similar fashion. So what that means is we can't negotiate rates or fees with any business that we license. So the restaurant in Peoria, Illinois has the same license agreement that the restaurant in Chicago does, with the same formula. It's all the same. If we were to negotiate different rates for different businesses, we would be breaking the law and we would be in trouble with the Justice Department. So just keep that in mind. PRO number 3, SESAC. They were founded in 1930. For a long, long time, they mostly represented religious music. SESAC was privately held, continues to be privately held. It was a family-owned company, and then a VC bought them a number of years ago and decided to try and go big time. So they signed up some fairly high-profile songwriters like Mariah Carey and Green Day, and now they have a small catalog, but many of the names in there are recognizable and are probably songs that you would most likely perform in your respective restaurants or bars. The difference between SESAC and BMI and ASCAP, and it's a very big difference, SESAC does not operate under a consent decree. And sometimes they'll go in there and their first rate quote to you is rather aggressive. And so my suggestion, my recommendation to you is to negotiate with SESAC. If they come in with a rate that's very similar to what you're paying BMI and ASCAP, there's something wrong with that, because they have a much smaller catalog, a much smaller percentage. So you need to push back with SESAC if they come at you aggressively with a high rate. Global Music Rights just came on the scene about 10 years ago. It was created by Irving Azoff, longtime music executive, used to be the manager of the Eagles. He said, I want to create a catalog that businesses cannot do without, and I'm going to price it accordingly. So he brought Bruce Springsteen, Bruno Mars, Pharrell Williams over from ASCAP and created Global Music Rights. Very small market share, but the market share they have is from songwriters that are very high profile. So you do have to deal with them. But again, same advice that I gave you about SESAC. They don't operate under a consent decree, but they will be aggressive in their pricing. And if it's any way close to what you're paying BMI and ASCAP, you need to push back, because they have about 5% of what we have when it comes to market share. Same with ASCAP. Finally, and this is something that's been a disruption in the space in recent weeks, a company called Alltrack was created in the last couple of years. They represent primarily independent artists, independent creators and publishers. They are being fairly aggressive these days in reaching out to restaurants and bars, and they're also reaching out to restaurant associations to try and do discount agreements with them. My word of advice about Alltrack is make sure when you speak to them, you ask them to provide you with a list of their most performed songs on the radio, because and I would ask that question, you know, of all these performing rights organizations. It's really good to understand what it is that you're paying for. BMI and ASCAP's music is on a searchable database on BMI's website. It's called SongView. You can find out all the songs we represent, you know, who's the publisher, contact information, so you have a better idea and understanding of what you're paying for. That's really important. SESAC has a searchable database as well. I believe Global Music Rights does too. At least they show on their website who they represent. Alltrack they represent a lot of independent artists. So it may be, in many cases, you don't need a license with Alltrack. And so if I were you, I would make sure that you fully vet that company when you talk to them and say, I want to know the product that you're offering that I am using. Because, you know, like a lot of companies in this space, it can be you know, they can present who they are and what they do, but it can be very confusing to you exactly who I'm paying for, what I'm paying for. And one final note before we move on, I get this question all the time. Do I need a license agreement with all these performing rights organizations? Well, ASCAP and BMI for sure, because that's the lion's share of the music that's out there. And so much music is co-written. There's such collaboration going on. An ASCAP writer could collaborate with a BMI writer, and there you go. You play that song, you need a license with both of these PROs. SESAC, there's some collaboration there too, and they have a catalog that's fairly recognizable, as well as global music rights. Alltrack, again, primarily independent artists. So vet them fully before you make any decisions on what to do. So why do you have a license agreement with a company like BMI or even ASCAP? It's because we offer a blanket agreement. In the case of BMI, it's more than 20 million songs that you have access to. I think it's up to 1.4 million songwriters and composers now. If BMI, ASCAP, SESAC, what have you, didn't exist, you'd have to go specifically to each and every songwriter and publisher and negotiate a rate. So even though sometimes we, in your mind, can be kind of a pain because we're fairly persistent, if we didn't exist, you'd have to license that music yourself, because we're simply doing what the copyright law was created for, and that is to protect songwriters. And you're creating, you know, you're supporting the craft of songwriting when you sign a license. And I think that's important to articulate, is that yes, your lawyer said, I must comply with the copyright law, and sure, the foundation for what we do is the copyright law, but I also want you to understand when you sign a license, you're helping songwriters make a living. You're fueling the creative process. So thank you for what you do and the role you play as a part of the music economy. This slide we're going to leave to the lawyers later on. They can talk a little bit more about that. And again, I said this before, I'll reiterate it again. The licensing dollars that BMI collects go directly to our affiliated songwriters, composers, and publishers in the form of royalties. This is how they make a living. And without this revenue stream, they don't, of course, have the motivation to continue to create new product. And who wants that, right? Music is the soundtrack of our lives. I put this slide up every year or every webinar that I do, because we have something within the BMI website. It's called BMI Live. It's an app that songwriters use to report their music use or their songs, their set lists when they play at bars and restaurants. And let me explain the background to that. When you pay licensing fees to BMI, it goes into the same pot of money that contains the licensing fees that the radio industry pays BMI. And we use radio data through the Shazam technology to then distribute those licensing fees in the form of royalties to our songwriters and publishers. We can be almost 100% accurate with that Shazam data. Because we don't have the technology yet, and we will someday, to pick up the performances of songs in Tuscaloosa, Alabama, or Bangor, Maine, we instead use this radio data, because the general consensus is that what's being played on the radio is also what's being played in bars and restaurants. The problem with that is, if you could just back up one more second, Kara. The problem is that with that methodology, what we're missing are those original songs played by the local singer-songwriter from Peoria, Illinois, who comes in on Thursdays, plays at your restaurant, might play 10 covers, and then might play 10 songs that they've written themselves. And so if they're affiliated with BMI, and I think ASCAP and SESAC have similar programs, they can upload their set list at the end of the night to their respective PRO, and they can get paid for those performances of those original songs. So I mention this to the business owners because you can make sure that those performers that are coming into your bar or restaurant every night and performing, if they're playing originals, they need to know about this, because we want to make sure they get fairly compensated, and you want to make sure when you pay those licensing fees that the monies are going to the right place. So please keep that in mind as you speak to performers and book them at your particular venue. Finally, real briefly, during the pandemic, like a lot of companies, we were trying to get creative and help out, the important customer base that we have, particularly in the bar and restaurant community. So we created a partnership with Gigmore. And Gigmore is an online booking platform that allows you to book live music fairly seamlessly. We can move on with the slides real quickly. Basically, if you're just getting started and you want live music and don't have any idea how to find a singer-songwriter in the genre that you're interested in Schaumburg, Illinois, you go onto the Gigmore platform and you can find artists, bands by genre and by market. And it's a very simple way to connect with artists in your area if you're just getting started with your live music program. So we'll save the questions for last, and we'll hand the ball off to Scott and Steve to continue.
Thank you so much, Dan. Scott and Steve from Sibwell Law Group, Fox Swibbo Law Group. Sorry about that. Please take it away.
Okay. Hi, everybody. So the law firm is Fox Swibel. We get it right about 50% of the time. So either one works. Just by way of background, the lawyers at our firm came from very large law firms, and they joined this firm, which is a Chicago-based law firm. So with the expertise we provide, this is the same advice that Fortune 100 companies are getting. We all worked for those companies. We all represented them. And Scott particularly represents some very large restaurants and groups like Let Us Entertain You, Hog Salt, Cheesecake Factory, many others. So he's an expert in that field. I'm an intellectual property lawyer. I've represented ASCAP for a number of years, even went to trial on their behalf. And I've also represented folks negotiating against negotiating licensing for ASCAP, CSAC, and BMI. So this perspective is, you heard the perspective from BMI, and we're going to provide you the perspective from us, who would be your lawyers or kind of represent your point of view. And the good news is that we're mostly in line. This slide here shows that as a small to medium-sized business, you're probably been approached by a number of claimants. And over the years, there have always been these parties that come at you asserting that you need to pay them for something. And the question always is, are they legitimate or are they trolls? For a while, there were a bunch of what we call patent marking trolls that came into stores and tried to find folks who didn't perfectly list every patent that might be applicable. There's always been patent infringement trolls, and there are some copyright trolls. There are some copyright, owned assertion entities that have very questionable title to the works that they come at you for. So those are in the troll category. But I will tell you that as far as these performing rights organizations, ASCAP, BMI, CSAC, GMR, these are all legit. And they're heavily scrutinized, as Dan said. The DOJ and Congress has a keen eye on them. So they can't charge exorbitant rates. And when they come in, they tell you that you need a license. You probably do. There might be some exceptions, which we'll talk about earlier or later rather, but by and large, these folks are legitimate. And if you don't take a license from them, you can get in a little bit of trouble. And if we go to the next slide, I'll explain why that is. So these organizations are duty bound to enforce the rights of their members. And that's important because a lot of times folks say, well, I'm just a small restaurant. If I perform some of this music without a license, nobody's going to pay to come after me. There's not enough money. I just did it one day, or I've only done it for a month. But with these PROs, they don't have the option of deciding that it's not worth it. They have to enforce their rights, that they have contracts with their members that require it. So you can't kind of limbo beneath the bar. If they've got onto you and realize you don't have a license, they're going to be persistent. I mean, they're going to keep coming. The other aspect of that is they will bring suit. if you do refuse to get a license. They will bring suit in federal court. And the Copyright Act has a very, very tough provision in there that requires, not requires, but it provides for the possibility of the prevailing party to obtain attorney's fees and statutory damages. So what does that mean? Whenever you bring a suit for IP, one of the difficult things to do is prove how you've been damaged. I mean, it's easy to kind of say, hey, I lost $2 million, but it's more difficult to prove it in court. Well, when you have statutory damages, you don't have to do that. It's set forth in the law what you're entitled to, and that makes these cases easier to bring. The bigger benefit, even more than the statutory damages, is the attorney's fees. And what that means is if you prevail, if one of these PROs prevails against you, they have a strong argument that you also have to pay the attorney's fees in connection with that lawsuit. So even if your infringement was minimal and you're paying, let's just say $30,000 for a performance, and that's not usually how the courts calculate it, but let's just use that as a starting point. If you force this case to go to trial, your lawyers probably spent, depending on their fee arrangement, $1.5 million going to trial, and they have an argument that you have to pay those attorney's fees. It's a provision that makes litigation under the Copyright Act very, very intimidating, even if you think you've just had, an infringement that doesn't arise to a very high level. The courts will not just look at, if typically the way these cases are brought is an investigator will come in, the investigator will record the songs that are played. And if you don't have a license and you refuse to get one, then you'll get served with a complaint. And, sometimes restaurant owners say, well, they only caught me on Saturday one time. So, what's the worst I can lose? That Saturday. Well, that's not really the way the courts look at it. Courts will look at the amount of time you remained unlicensed and calculate the damages that way. So long story short, it's, as I said before, it's very difficult to limbo underneath this bar. If the PROs are onto you and you're unlicensed, the best and easiest way is to get caught up and get a license. I've litigated a number of these cases. I've seen people try to squeak out, pulling out, provisions of the Copyright Act, pulling out the First Amendment. It's never worked. I'm just going to tell you the same thing. If I were your defense counsel in these cases, they're not worth fighting. And boy, you can get that attorney's fees hammer, and it's not nice. So what I always say with IP, and I guess people are not, the younger folks haven't heard the possession is 9/10 of the law saying. And what it used to mean is that whoever holds something that like a piece of land or holds a piece of property that you can touch and pick up, you have a stronger claim to it if you have it at the moment. But IP is not like that. Intellectual property, songs, music, it floats through the air. It's so easily copied from a technical standpoint. So just because you have access to it does not mean that you have possession of it. So one example is, say I buy a CD, a Taylor Swift CD. And then let's just say that a big movie company wants to make a movie and put Taylor's, Swift's music on the soundtrack, or sell CDs in connection with the music. Why would they go to Taylor Swift, who's going to negotiate a large price, or her publishing company or her agent or whoever represents her? Why wouldn't they just come to me, who bought her CD for $9 and have me say, hey, here's the CD, you can use it as you want, right? Well, the answer is that I only have a limited license when I get that CD. The license for me is for a personal use. And everything you can find on the internet in terms of music, movies, artwork, even if you can download it publicly, that doesn't mean you have a license to make money off of it or reproduce it or distribute it. And the question of what you're allowed to do with it, very complicated, right? Copyright law is not a simple law to apply. So you don't have to understand the full scope of the copyright law and what elements you can and can't use. But the understanding that just because it's on the internet, it's free to use is absolutely a misnomer, and it can still get you in a lot of trouble. So if you have a restaurant and you say, oh, I'm just going to find a YouTube playlist and publicly perform it because it's on the internet, and it's not good enough. This next slide is about fair use. I always get asked about fair use. Is my use of this trademark, is my use of this music, is my use of this image fair because I'm not directly selling it? Fair use is a very fact-intensive area of the law to apply. And that means if you're relying on fair use for a defense, it's going to be hard to get out of a case early. It's very difficult on a motion to dismiss, which happens early in a case, or even on a motion for summary judgment, which happens a little later in the case, to win your fair use argument because it's amorphous and it's factually intensive. But even more so, in the last month, the Supreme Court has issued 2 rulings in the context of copyright and trademark. They're pretty nuanced, but the upshot of it is they've really restricted the fair use law when you use works that are in any way commercial to make money. Even if you're commenting on them, even if you're adding something to them, the scope of fair use has gotten smaller. It's something that's pretty difficult to rely on. And for about 100 years or so, folks have tried to argue fair use in connection with these performing rights. It's not going to work. It doesn't save you in this instance. And even with other types of IP, be a little bit wary. The scope is getting a little bit narrow these days. Okay, so tips for negotiating with the performing rights organization. So this is kind of the stuff we do when we represent, usually not individual restaurants, but we'll represent like larger hotel groups, folks that have a little bit more of a complicated setup to determine what license they need. So the first one is just figuring out who is already licensed. Sometimes hotels or restaurants have management groups, and sometimes even unbeknownst to themselves, a management group will get, say, a BMI license, but they won't get an ASCAP license because the individual venues get ASCAP licenses. So when it comes to this kind of stuff, when you get approached by a PRO, you got to do your homework and figure out if you have different entities, if you're part of a management group, who's licensed. These licenses are done on location by location basis. And the representative from the PRO might not know that you're part of a management group that's licensed through them. When they come to you, they might not know that. They may know that, they may not. So make sure you check that out. What type of music are you using is important because the rates are different. If you have live performances, the rates are going to be a little higher. Karaoke, maybe not quite as high, but different. And then, as Dan mentioned, the televisions. If you have music that come through broadcast on televisions, if you have sound, you're going to need a license. But if you're the type of business that can operate without sound in the bar, this is really a bar area thing, then you might not need a license as long as you know that sound's going to stay off. These licenses are not overly long. There's a lot of legalese in them in terms of limitations of liability and, the kind of everything after the first 2 pages of the contract. But usually take a look at the first page of the contract when it describes the venue type and make sure that language is clear. Some PROs, I think, use language that's a little too broad, and they want to license like nightclub venues where the primary thing that they provide is, the entertainment, in which they charge more for. And sometimes that language can kind of sound like you, especially if you're like a hotel or a restaurant. And so I always say, just read that from a plain language standpoint and make sure it describes who you are and what you do. And, you don't get caught up in a definition of like a nightclub or something like that. Be truthful. As I mentioned before, these folks can't gouge you because, they have DOJ oversight. Even the ones like CSAC and GMR that are not technically bound by consent decrees, they still have to be wary of it because they're not, they don't have a get out of jail free card if somebody decided to challenge them in their licensing practices. So, don't try to hide the ball. It's easier to just be upfront with what you have and get a license that covers it. And as I mentioned before, you don't want to lose disputes on this because that attorney's fees item is a lot. All right, in just the last couple of minutes, I want to touch on other areas of intellectual property. Dan mentioned intellectual properties. The music that we've been talking about, that's under copyright. There's other types of intellectual property, trademarks, the name of your restaurant, how people identify you. Those are the two big ones in the restaurant industry. When it comes to recipes, typically those are trade secret. It's very hard. It's very difficult to protect recipes. I mean, it can be done, but as a practical matter, sometimes you spend more time on lawyers and getting contracts than meat of enforcement you actually get out of it. So those are the big ones to keep in mind. Patents, I mean, they don't really come up in the restaurant industry, but trademarks and copyrights are specifically difficult because they're so readily available on the internet. They're easy to copy and they're easy to distribute. So it's something to be aware of. Okay, so we can maybe just breeze through some of these. The copyright is a little different than the other types of IP because it's automatic. So as soon as you create anything original on your own that has even a minimal amount of creativity, you automatically have copyrights in it. Anyone does. So if you go to the next slide, arguably, when you write an email, you have a copyright in that email. Arguably, when somebody forwards that email from you, they violated your copyright. The Copyright Act is very large. It's very complex. If you have questions that you need to talk to a lawyer, it's very difficult to figure out on your own unless you've been practicing in the industry for a long time. This slide is just an example of YouTube terms of use. So you'll notice that if you could go right back to the YouTube one. This is what YouTube tells people who upload videos. Like when you upload a video, you must license it to other people, but only as enabled by a feature of the service, such as video playback. So this is just an example that somebody who puts something on YouTube can point to the court to say, I did not give you a license to download my video and reproduce it to make money. Even if it's on YouTube, you can't use it to make money. The license only extends to, playing the link through the service. And then even if there isn't a written language, there's a broad body of law that handles implied licenses. So even if it isn't written down, the holder can argue that you've gone beyond the implied license. Okay, so we kind of touched on that part. We can go straight to the questions.
Great. Thank you so much, Steve, Scott, and Dan. Let's get to questions before we conclude today. So how does a business need a license if they only play original music?
Let me take a shot at this because it's a question that I get quite often. All music is original, right? The question is if a song, and I kind of alluded to this earlier, when you have a local artist, singer, songwriter performing their own original music, I guess basically to sort of to re-ask the question, I think it's if they're not playing cover songs, do I need a license, right? They're not covering other people's music. And the answer is, if they're affiliated with a performing rights organization, then yes, you do need a license with that PRO. And most songwriters, if they've been properly educated earlier in their career, will be affiliated with a performing rights organization because in most cases it's free. It's free at BMI. Why wouldn't you want a PRO to protect your rights and track your performances on YouTube, Spotify, radio, what have you? So if you are trying, and I hate to answer this question this way, but I want to be fully transparent. If you are trying to avoid paying licensing fees to performing rights organizations, which I don't necessarily recommend, but if that's what you want to do, then you make sure that anybody that comes in and plays in your respective restaurant that's playing only original songs, no covers, because then you would definitely need licenses, but they're only playing covers, find out for them Are they affiliated with a performing rights organization? If they're not, they say, nope, I'm not BMI, I'm not ASCAP. And that's the only kind of music you have in your establishment is this local singer-songwriter playing their own original stuff and they're not affiliated. Then you don't need a license for that. But most songwriters / artists are affiliated because it behooves them to be. They leave money on the table when they're not properly affiliated.
Yeah, and one way I like to think about this is, so each of these PROs, they have, their individual catalogs of music. If you only wanted to take a BMI license, you could take your playlist, go song by song, search in BMI's repertory, and for every song that's not in BMI's repertory, delete it off your playlist. And then you're ended up with just a playlist that you have through BMI. You could do it. Practically, nobody really does that. But if somebody's performing original works and they're not included in these repertories, then you don't need a license from them.
Great, thank you. So how do you know that a PRO is legitimate when they walk into your bar or restaurant?
Well, I think the ones we've talked about, we know now those are legitimate. They've been around long enough that they are. If you hear from someone else, it might be worth asking a lawyer who handles these issues to, kick the tires on it. It's easier in the music space than it is in the other copyright space, because there are other trolls that that might come at you for images you use on your website. And there have been some cases that is pretty clear that there have been fraudulent assertions of use of images. I mean, just even stock images for food on the website. Thankfully for music, you can pretty much rest assured that these big four are legitimate.
And also I would recommend that, that you reach out to the association, to the IRA, and if they need to bring me into the conversation, I'm always happy to help. It doesn't have to be BMI related. I've been doing this long enough that I do understand the landscape and I can provide insight into these PROs. I know it's very frustrating right now because you're like, how many more are going to pop up, right? I'm already paying BMI, ASCAP, CSAC. Maybe I'm paying GMR. I've been reached out to by Alltrack. Who's to say that Steve and Scott and I won't start a PRO tomorrow? I mean, there's nothing that prohibits us from doing that. It's very difficult, though. I mean, it's very difficult to have a PRO because you have to have an infrastructure that allows you to track all this music and then cut royalty checks based upon those performances. It's not easy, but please feel free to use me as a resource.
Yeah, great. We get questions about this all the time at the IRA, so feel free to reach out to us at the IRA, and we remain a business source in general for all of these things. And then let's get to a few more questions before we wrap up. Do you have to pay all of the kind of big three of the PROs?
So that goes back to my example. The answer is
Yeah.
practically yes, unless you did the work of going through and making sure that your playlist is only going to have, I mean, the big three for sure, ASCAP, BMI, and CSAC. But then GMR, I mean, the artist, can you avoid a Bruno Mars, knowing that a Bruno Mars song is going to come up on whatever playlist you have? That's going to be difficult. I really think from a risk standpoint, this is something where it's just easier to build it into the cost of doing business.
And before we get to the next question, I want to remind everyone that you will get a presentation, you will get the slide deck, as well as contact information and this recording at the conclusion of this. So any questions we don't get to, I just want to remind everyone. We did have a question about the definition of square footage of a small bar. I think, Dan, you touched on this.
Yeah.
So a small bar, what is needed for licensing there with PROs?
Well, I mean, I don't know if Steve wants to tackle this, but basically, regardless of the size of the bar, if you're using live music, or you're streaming songs off your personal account, or you have karaoke or a DJ, or you've got trivia where you're featuring clips of music and such, you need a license. The only time that you don't is if it's a commercial radio station that you're broadcasting into your bar or restaurant. And I believe the exemption is, I've been doing this long enough. If you think I have this number in my head, I think it's 3,750 feet or less. Then under the copyright law, there is an exemption, but again, it's only for commercial radio use. That's it.
Yeah, I would agree with that. The reason Dan can't remember is because it just doesn't really apply anymore. It doesn't come up very often.
It doesn't.
So, TV sizes, you can't have a screen larger than 55 inches. That used to be a big deal. Now, I mean, it's hard to find a TV that's not 55 inches, right? And then that exception is always only for retransmission of broadcasts. So if you have anything coming through that's not, a broadcast under the FTC, it's not covered. So, these type of exceptions just they rarely come up. They're rarely going to save you.
And I would say just, we haven't talked about this at length and we don't have time to, about how the license fees are determined, but the smaller bars obviously pay a lot less than a larger bar because the foundation for the fees with BMI is the square footage, the fire code number. I shouldn't say square footage, it's the occupancy number. Actually, it's the fire code number, which equates to and connects to square footage.
Hey, Steve and Dan, I have a question that I get all the time from clients, which is, I already have a license with Pandora or with Spotify Premium. Why can't I just simply pipe in Pandora into my restaurant?
Right, you could. You just have to pay the fees for it because no one's paying the licensing fees on behalf of Pandora unless you have Pandora for Business. I think it's analogous to, hey, I'm gonna sign up with Comcast as a personal subscriber and then put five Comcast TVs with Comcast programming in my bar. Well, you don't have a commercial license to do that. You have the right to have that subscription in your home, just like you and I have the right to play our favorite songs off Spotify in our home. That's not a public performance. But once it's in a public space and it's not pre-licensed through a background music service, then you must license it.
Yeah, Kara, could you jump back to slide 13?
Yes, one more.
I think this is the way I think about it. So when you have a piece of music, it starts with a composition. And so that's the notes written on the ledger and then the lyrics underneath. Go down a little bit more. That one with the number, or 51, sorry. Yeah, okay. So then the royalties get split in two ways. One goes to individual use. That's people who buy the CDs or buy merchandise or go see a show. The performers largely get the royalties there. That's the guy sitting on stage that's shown there. And so I put like a little icon of one person. That's individual use. And that's what Sirius gives you. That's what Spotify gives you. It says, hey, I'm providing rights for individual use and the royalties track that. But that ignores that there's a whole separate area under the Copyright Act of public performances, and that's on the right side. That's the underlying composition. That's where the rights come from. And those are performances where you see a group of 4 people there. Those are performances to large groups of people. And so you have to determine whether the service you're providing is giving you the left side license, the individual one like Spotify, or the right side license, which is like ASCAP, BMI, or Soundtrack Your Brand, the types of service providers that will tell you they carry a public performance license. So that's the name of the game. Find out if the service you have carries a public performance license.
Great. It looks like we are literally out of time. And I appreciate everyone participating today, specifically Dan, Scott, Steve. I think we have more questions, but I want to remind other participants here and attendees that you will get a copy of this deck as well as the live performance, including our contact information. And we look forward to you engaging with us at the Illinois Restaurant Association and the Cook County Small Business Source, which we are only able to do this through their partnership with us, and we appreciate them. Thank you, all attendees, and we will follow up with any questions that we were unable to get to. And thanks, Dan. Thanks, Scott. Thanks.
Thank
Steve.
you all.
Thanks, everybody.
Thank you
Thanks,
all. Have
everybody.
a wonderful Thursday.
Thanks.
Bye.